Keroge is good. Thank you.
Good. Okay. Yes, so we'll begin with a very quick introduction. My name is Martha Komi, the chairperson of the JSC. I welcome you for this interview.
Thank you, Chief Justice.
Good morning.
Good morning. It's afternoon.
Or is it afternoon?
It is afternoon, I guess.
Isaac is my name. Isaac Ruto, also Vice Chair.
Good afternoon, Commissioner.
Good afternoon, Your Honor.
Good afternoon,
Commissioner. You're welcome.
Asante.
Good afternoon, Mheshimiwa. Zilani Caroline, Commissioner Karibu.
Asante.
Good afternoon. I'm Charity Kisoto, Commissioner. Welcome.
Asante.
Good afternoon, Omwanzo Mbati, Karibu.
Thank you.
Good afternoon, Jokindomo.
Thank you, my lady.
Yes, good afternoon, Your Honor. Anthony Mloima, Karibu sana.
Nashukuru.
Good afternoon, Your Honor.
Good afternoon.
Fatuma Sichale, Karibu sana.
Asante.
Good afternoon, Mheshimiwa.
Good afternoon.
You're welcome. My name is Olwanda Evelyn.
Thank you.
Good afternoon, Dorcas Odor, Senior Counsel, Attorney General.
Thank you so much, Honorable Attorney General.
Thank you for that introduction. Mheshimiwa, make yourself very comfortable.
Thank you.
Relax, because we want to have a conversation with you. Although it's an interview, we want our candidates to feel at home and feel safe. We are non-threatening. Absolutely.
Thank you.
Yes, we are just carrying out a very difficult exercise. So if you could start by telling us your county and your ethnicity.
My county is Machakos County. My ethnicity is Kamba.
Right, so we'll start, and we want to hear from you. What motivated you to apply for this position? What particular skills, knowledge, experiences, values are you bringing to this court? We had a stakeholder engagement with stakeholders, and they told us they want people who are hardworking. Actually, they describe them in the language of a farmer, a tractor. Because you know the challenges we are facing in the High Court. So therefore, we want to hear from you. We've read your CV and the material you presented, but we want to hear from you how you're going to help us deal with those challenges that we are facing in the High Court and the reason why we are recruiting.
Thank you, my Lord Chief Justice. Allow me to start with my qualifications. My academic qualifications is that I hold a Master's in Business Administration from Kenya Methodist University. I also hold postgraduate diploma from the Kenya School of Law and a LLB degree from the University of Nairobi. Why my work experience, my Lord, work experience is that I was admitted to the bar in the year 2001, meaning that I have 25 years post admission qualifications. I had a very short stint with an NGO, a non-government organization by the name World Neighbors. I started off as a volunteer with World Neighbors, and immediately after my admission, I was absorbed or employed by World Neighbors, where I had a stint of 1 year. While I was there, I worked with the marginalized, and that is where I was motivated to join the bench. In the year 2002, when an opportunity arose in December, I applied and I was appointed as a District Magistrate 2 professional. Since 2003, when I was appointed, I have been with the judiciary. I have remained with the judiciary, where I have worked in different stations. My lady, what I would describe myself as a good judge and how I fit this bill, I would want to cluster my qualities into three: whether I fit the constitutional parameters of a judge, in terms of qualifications, in terms of observing the national values as enshrined in Chapter 10 of the Constitution and Chapter 6 on integrity, to say that I fit that bill, the constitutional mandate of a public officer. I would also want to cluster in terms of integrity, accountability, transparency, and selflessness. What has kept me grounded for those years, it's because I am hardworking and I observe integrity. I have not had integrity issues raised for the time I've been working with the judiciary. The other cluster I would like to cluster how I fit the bill is the hard skills. The hard skills in terms of professional. Sustain me is the mentorship from seniors, and as well as I've acted as a mentee. The soft skills, my lord, temperament, humility, hard work, good communicator, and what Wanjiku wants is a responsive and efficient High Court that hears Wanjiku when Wanjiku comes to court for hearing. How do my vision for the High Court is to have a very responsive and effective High Court, deal with the issues of backlog and the issues of efficiency. How I intend to deal with the backlog, my lady, is that should I get this opportunity, hard work. There is no substitute for hard work. Thank you.
I will hand over now to Commissioner Mwanza to
Okay.
take us to the next level of questions.
Thank you. Perhaps there is also Mora. It's not only Wanjiku.
Thank you.
All right. I see that in one of your writings, it's about a fatal accident claim.
Yes.
Now I want to ask you something that is almost related. It's with respect to lost years damages. So you have a child who suffers brain injury at birth. That was as a result of clinical negligence. And out of that they get palsy. Then they have to depend on others to maintain them. And the doctors agree that their life expectancy will not be beyond 29 years. They come to your court to assess damages recoverable for the years, because it's in terms of life expectancy for a Kenyan person, maybe it's 65.
Yes.
But because of that negligence at birth, it's been shortened to 29 years. The question is, are lost years recoverable in principle? That's the first question. The second is in assessing those lost years, because they've said up to 29, that is what is agreed by the doctor.
Yes.
Between 30 and 65, would it be speculative to say that were it not for that negligence, this child will have lived to 65? And lastly is damages for financial loss during those lost years recoverable in common law?
Thank you, Commissioner. The first question on whether lost years are recoverable, my answer would be yes. The assumption is that this child would have lived to adulthood and would have enjoyed a good and productive life in absence of any other evidence, which in this case you're saying this is a child that has suffered cerebral palsy
Yes.
at birth.
Yes.
So I would say that yes, they are recoverable. How would I calculate? Will they be speculative? They would be, because there is no evidence at that point to say what this child could have become. At birth, it is hard to tell.
Actually, that's a precise question, because
Yes.
if it was maybe a teenager, maybe they've been in school, then you will have seen their progress.
Yes.
Or if they are a young adult, you'll have seen their progress.
Yes.
So then how do you assess this?
How would I assess this, my Commissioner? I would use the minimum wage. I would look at if this to the age of working economically. I would use the minimum wage. Other decisions I've seen where they say one can also use a global sum based on precedent. Yes.
Okay. And what would be the financial loss recoverable?
Sorry, come again.
The financial loss. What would be the financial? So you how would you quantify the financial loss? You say through a global figure.
I could either use a global figure, or I could use the multiplicand.
Okay.
Multiplicand, where I would say if this child grew to start working at 24 for 30 years at the minimum wage, I can adopt that multiplicand.
Okay.
Yes.
All right. I have one other question. I want you to look at Article 32 of the Constitution. If you look at Article 32(1), actually if you look at the entire 32(1), 2, 3, and 4, it starts with every person has a right. Every person has a right. A person may not be denied access. A person shall not be compelled to act. So that article emphasizes on the person in terms of their freedom of conscience, religion, belief, and opinion. So the question I want to ask is whether a person not belonging to, say, a religious denomination, say there's an atheist, and they want to question a practice about Sabbath of SDS, would they have standing to come through PAI, through public interest litigation?
This is every person means yes, they would have, as long as they can demonstrate what is their interest.
But the person,
Yes.
the right that inures under 32
Yes.
is to the person who professes. The person who professes. Just read, for instance, it's
Yes.
at 32(1) says, every person has a right to freedom of conscience, religion, thought, and belief. Then, 2, every person has a right, either individually or in community, in public or private, to manifest any religion, belief through worship, practice, teaching, observance, including observance of a day of worship. So there is a dispute before you, by and it's brought as a constitutional dispute by an atheist. And this atheist, who says he does not believe in anything, in a God, wants to protect the right of Seventh-day Adventists to profess their faith and practice Sabbath on Sabbath. Will they have standing under public interest?
They will. They will have a right. They will have standing.
Okay. And lastly, then, what is the interplay between the right of a person now under 32,
Yes.
and the right of religious denominations?
The interplay between a person.
The right of a person.
Yes.
Now, this is the person who, the Kenyan, or the person who is practicing their faith, and the right of denomination, say SDAs, or even Muslims or Catholics.
If you could rephrase kindly, Commissioner.
So,
If you could rephrase
would will both of these rights be on the same plane? Is there one that would have more weight than the other? The right of persons, in terms of the person's right to practice faith, and the right of a church, for instance, to establish itself.
I believe they'll be at the same standing.
Okay.
Thank you.
All right. That's all, CJ.
Thank you.
Thank you, Honorable CJ. Honorable Mutuku,
Yes, Commissioner.
Magistrate from the year 2002.
2003.
2003.
Yes.
Indeed, a very long period, eh?
Relatively long.
Yes, so I'm sure you have all the experience in terms of the substantive law as well as the procedural law. I'm sure when you started as a district magistrate too, there was no requirement that when a litigant files a plaint, it has to be accompanied by documents, list of witnesses, etc., etc. Is that correct?
That is correct, my lady.
When did it change?
It changed when the oxygen rule was introduced. I might not be very clear.
Yes.
I think we take that, we assume some of these things when they come, but I remember when the introduction of the oxygen rule, 2007, it's a guess, my lady.
All right, okay.
Yes.
So anyway, there were amendments that were made to the civil procedure rules.
Yes.
And the requirement now is that you have to provide witness statements, copies of documents that you need to rely on, etc. So imagine that you are undertaking a trial, the pleadings closed, and now the hearing started. And the defendant applies to court wanting to introduce new documents and other witnesses that he had not provided their statements. How would you go about that?
A defendant has a right to seek, to move the court to seek for introduction of new documents and witness statements during the pendency or at whatever stage of trial. If it is after the close of pleadings, my expectation is that the defendant will seek leave of court to introduce the new documents.
Under what provisions of the law, where do you get that from in terms of the civil procedure rules?
The civil procedure, the specific...
that gives the right that you can introduce other witnesses that were not contemplated at the start, as well as documents that, again, you did not provide initially.
From the civil procedure rules?
Yes, where from the civil
specific section, my lady?
Yes.
That one, I must admit that I don't have it on the top of my mind.
But is there a provision in the civil procedure rules that allows for a defendant to bring these additional documents after the documents have been exchanged, pleadings have closed, and trial has commenced?
Yes, there is such a section, and that's why this defendant would have to seek leave, my lady.
I have looked for that section and I don't see it.
Then I stand to correct it.
And then you're also telling us that even if after the plaintiff has closed his case and the defendant is seeking to introduce this new evidence, as it were, upon an application being made, he or she can be allowed to do that?
If these documents do not cause prejudice to the plaintiff's case,
they definitely would cause prejudice, and that is why they are being introduced.
If I hear the application and find that there is prejudice, I will not allow the application.
Why?
Because of the pretrial, at the pretrial stage, That is when parties are expected to present all the documents for just and expedient conclusion of this case. So if a party seeks to introduce any documents late in the day that are going to cause prejudice or injustice to the other party, then I will not allow the application.
But invariably, they
Yes.
would be causing prejudice, and that is why they are being, he's seeking to bring them on board. Because if they were of no effect, surely he wouldn't be asking to bring them on board.
Parties will come to court and give different reasons as to why they did not have these documents in the first instance. Such that if also there has been amendment of pleadings.
Remember, we said the
Yes.
plaintiff has closed his case or her case,
Yes, my lady.
and now we are at the defense hearing.
Yes.
And it is during this time of defense hearing that an application is being made to introduce documents that had not been provided earlier on.
My lady, my position is that if it is prejudicial to the plaintiff's case, I will not allow that.
And I'm saying everything is prejudicial.
Then
Let's begin from that premise.
Okay.
Yeah, everything is prejudicial to the plaintiff's case.
So, my lady, I'm seeking clarification. Everything is prejudicial, so my decision is not to allow the application for the introduction of those documents.
Well, at that point in time, the plaintiff has closed his or her case. Will they have an opportunity to rebut what the defendant is trying to introduce?
Through reopening or through cross-examination?
They have closed the case.
They have closed the case. It will cause a lot of prejudice if they're not given an opportunity to rebut. The only rebuttal they might have, my lady, is only through cross-examination.
And that is what I'm saying, that you need to take into consideration in an
Yes.
application whether to introduce new documents or not.
Mm-hmm.
And then I think the fallback situation is that because there is no provision in the civil procedure rules that allows for filing of additional documents, the fallback situation usually is Article 159.
On the yes, on the Constitution, I stand guided.
Thank you. Thank you, CJ.
Thank you, Honorable Chief Justice, and Your Honor, once again, karibu.
Asante.
Now, which is your station?
Kerugoya.
Kerugoya. Okay. Among your CUC members includes the chief and the local administration, isn't it?
Yes.
Okay. And you must be aware that under the Chiefs Act, the chief has some powers to issue some order for certain purposes and to require people within the jurisdiction or a certain area to obey. It's provided for under the Chiefs Act. For instance, let me give you an example. For example, can issue an order prohibiting the consumption or restricting the consumption of intoxicating liquor. Can also issue an order prohibiting or restricting holding of and drinking boats, the dens. Can also issue orders regulating cutting down of some trees or planting some trees, destruction of trees, preventing spread of some disease, or even preventing pollution of water in a stream or a water course or a water hole. These are some of the powers which a chief can exercise under the Chiefs Act.
Okay.
Now, in view of the 2010 Constitution, how will a chief go about issuing any of these orders I've mentioned above? How is a chief supposed to approach that under the 2010 Constitution?
Issuance of orders by the chief.
Yes. Before the chief issues these orders, and looking at it from the lens of 2010, what is this chief supposed to do?
I would say that under looking at the developments in the 2010 Constitution, the chief will require to call for public participation.
Good.
Because this is something that is going to affect the public. So his decision should be guided, and he should first seek a public participation, I guess, through barazas or any other means.
And in seeking the involvement of the public, which rights or freedoms will the chief be advancing? Just looking generally at the Bill of Rights, which are some of these rules, these are rights which the chief will be advancing?
Will be advancing the right to information, because the members of public will be affected. They need to know the information that and the implications of the chief's orders.
Transparency.
They need to be transparent, and they need to be very, very clear. The orders of the chief might affect other orders, some other rights. I'm imagining if it is maybe the right to association, right to economic activities, if it is about trees.
Yes.
There are people that would rely on trees for maybe charcoal or firewood. That would, by extension, affect the right to economic activity.
Okay, so
yes,
in the end, will we be right by saying that regardless of the position you hold in government, you have no option but just to abide by Article 10 and the other provisions of the Constitution?
As a public officer, there is no option.
No option.
There is no option. It's not optional.
Thank you.
You must abide by the
Thank
values and integrity chapter. Thank
Wish you the very best. Thank you.
Thank you, Commissioner.
Yes, good afternoon.
Good afternoon, Honorable AG.
Kindly outline
Yes.
the High Court's role under the Insolvency Act 2015.
One that comes to my mind under the Insolvency Act will be the appointment of an administrator. That is one of the roles that is of the High Court.
Administrator to administer?
Sorry?
Administrator to administer?
To administer the companies that seek to be, to administer the assets of the company.
Administrator?
Yes, sir.
Okay.
Administrator. Yes.
Another
one? None that I can think of right now, but I'll be able to think through it as we progress.
Okay. If we can move forward, it has a supervisory role, and also it has an adjudication mandate. Can you remember 2 examples where the High Court would be acting as a supervisor or where it would be adjudicating issues?
As an adjudicator, this is where the parties will present their case before court.
Which parties?
It will be the company that is seeking to all the creditor.
Okay, let's
go
to
court.
We go to another question.
Yes.
To make it easier.
Yes.
Under what circumstances would the High Court depart from its decision or the decision of a court of equal jurisdiction?
My general take is that a High Court is not bound by the decision of our concurrent.
Under what circumstances would a High Court depart from its own decision or the decision of a court of equal jurisdiction?
Or from its own decision. It will depart from its own decision where there has been new developments in law or where we're seeking clarity on matters. that have come before it.
Seki?
I'm saying that a high court will depart from its own decision where there are new matters of law or there are new developments in law. But the court will be expected to distinguish and see where they are departing from their very own decision.
Okay, thank you.
Thank you.
Thank you, Chair. Good afternoon once again, Your Honor.
Good afternoon,
Do
Commissioner.
you want to take some water?
I've been taking water, thank you. Okay, thank you.
Okay. I've gone through your sample writings. You submitted to us decisions in family, succession, and criminal cases, in fact, complex criminal cases. Collectively, they portray your ability to identify issues precisely. You have strong doctrinal application of law to facts. You carefully evaluate evidence, and your reasoning is coherent. So I commend you for that.
Thank you.
And from your writing, you appear to incline towards contextualist. Don't know whether that's appropriate way of defining you.
Mm-hmm.
And then your tone is calm, balanced, and impartial.
Thank you.
In one of the sample writing, this is a succession matter where you allowed a widow to have actual share of the late husband's estate. Why did you depart from what the law says? The law says a widow only has a life interest.
In this case, Commissioner, I was dealing with an issue where the deceased seemed to have, what did I say? He seemed to have distributed his estate during his lifetime. So there was evidence that all the children, all the beneficiaries had been given property prior to the demise.
Yes, which was still registered in the name of the deceased person. So the question is, if you could just maybe focus on the question.
Yes.
The law of successions provides that a widow and a widower only get life interest over property. But you went ahead to give her an actual share of part of the deceased person's estate.
I gave her a share because she ought not to have been discriminated because she is a widow.
Mm-hmm. How about the Law of Succession Act?
The Law of Succession Act says that she is entitled to a life
interest. Yes.
Yes, life interest.
Uh-huh.
Yes. So my consideration was that being a widow, that she is entitled to a share of.
So what guided you to make that decision that is outside what the Law of Succession provides?
I was looking at Section 40, this distribution of property. You look at what the wife, you look at the households, the number of children, and that the wife is entitled to a share.
Other than the Law of Succession, what else guided you? Because as I said, the Law of Succession tells you to give a widow a life interest and not actual share of the property.
What they seem to have had this land is matrimonial property. Mm-hmm. This is where the widow was left by the husband, and this was matrimonial property.
Okay.
Yes.
Thank you and all the best.
Thank you.
Are there any limitations to freedom of media as provided for under Article 34?
The right to media is not an absolute right.
And
so there are limitations to the right.
Can you give me an example of some of the issues that may arise that may limit the media?
I would think of if the media is seeking to incite.
Yes.
Insightful or content. I would think of hate speech.
Mm-hmm.
I would think of propaganda, war propaganda.
Yes.
Yes.
Yeah. So you are correct. Those are all provided for
yes.
as exceptions in the Constitution.
Yes.
But the courts have developed through case law further exceptions. Is there any that comes to mind?
Right now, none, my lady. Right now, unless you guide me.
Recently, well, about a year ago, I think, the Supreme Court determined a decision on televised coverage of children who had been charged in court.
Yes.
Are you aware of that case?
I am aware. I've read that case, my lady.
And what did the Supreme Court find? Because the media was saying it's a matter of national interest.
Yes.
There's freedom of the media. And the parent was the petitioner or the respondent was saying no. This is an exception to freedom of the media. What did the Supreme Court say?
In that case, the Supreme Court protected the right of a child to privacy.
Yes, yes, indeed.
And the Supreme Court said that the media cannot air or publicize the children, that they had to hide their identity. And yes, that is, I think, that the court upheld the rights of a child under Article 53.
So the media cannot identify children in criminal matters who are before courts.
Yes.
Who else are the media not allowed to identify?
There are protected witnesses.
Yes.
So if this is a protected witness, the media cannot identify. There are matters of national importance. So where at times the media will have to be excluded if the court, the submissions are that these are matters of our national importance.
What about sexual offenses?
Sexual offenses, yes, they cannot be allowed to publish.
Okay, thank you very much.
Thank you, my lady.
Thank you, Chair. Good afternoon, Mheshimiwa.
Good afternoon, Commissioner.
Okay, I just want to have a very brief engagement on your report from DISPOP.
Yes.
You have seen the report.
I have seen my report.
Is it accurate?
The one that was sent on my personal performance and the court station, I noticed there is an issue with the backlog.
Yes.
The backlog of 29 and the backlog of 10 cases that are older than 10 years.
So just a second, I think I got the wrong one.
There's the one on the soldier report. And
yes,
the
29 and 10, yes.
Yes, so there's that one that was sent to the individual report. That one I noticed that there's a mistake.
I have the one that indicates that your backlog is total 39, 10 and 29.
Yes.
This is accurate, or this is the one that has issues?
It's the one that I noticed that had issues.
Yes.
I looked at, immediately I got the report, I looked at the soldier report. That seems to give a more, I would say, accurate and position of what the station is like.
So the soldier report is giving a better
It's giving
picture.
a reflection of what
The
I
station
confirmed,
is like.
yes.
So what is your pending caseload?
Pending caseload, according to that report, is around 22,580. Around that figure, according to that report.
No, I'm talking about the soldier report, because you told me this is not accurate.
Yes, the soldier report, when I was discussing with the department as at the June, was around 3,180, thereabouts, with a backlog of around 700 cases.
I was about to commend you based on this report, because the backlog situation looks like you are on your way to clearing backlog, and all your cases look like they are current. But I appreciate the honesty. You've pointed out that the situation is not as glorious as this report is showing.
It is not, my Commissioner.
Yes. I'm quite happy with your output. You seem to be carrying more than your weight. If we leave the backlog situation aside, because it has issues, yes. I'm looking at your performance, individual performance, from 1st July 25 to December 2025.
Yes.
Yes, your output is 39% out of the expected 25%. I think that's commendable.
Thank you.
That translates to 156% performance at an individual level. That is good. Your case clearance rate is also quite good at 110 as opposed to, I mean, as against the 104% national average. The place I wanted to ask you about is the court productivity. Your court productivity is lower than the national average at 249 against 370. Maybe you could tell us why this is happening and what it means to you generally.
I would say the court productivity at Kerugoya is affected by the cases, the nature of cases that we'll hear. Most of the cases are land cases, succession cases, that more particularly the land cases take long to resolve. So I would say that would be one of the issues that is affecting our productivity.
Okay, what your caseload you said is at about 3,000. How many officers are there?
We are 4 currently.
4 officers?
4 officers, yes.
Do you think you're overstaffed and that is what is causing your court productivity to be low?
We are not overstaffed, Commissioner, because every judicial officer at the station has a special responsibility. So we have the head of station, who has as head of station has a special responsibility. The other officer is the DR ELC court. The other officer is the DR High Court, and then we have the small claims court adjudicator.
Okay.
So that all the 4, besides the court work, have other special duties. So I would not say we are overstaffed.
Okay.
Maybe the special duties for the DR work might not be reflected in that report.
It is
but
not.
in terms of actual work being done and in terms of activities of the station, there is a lot of output of every judicial officer. That we are all occupied.
Okay.
Yes.
You know that you interacted with the soldier report, especially in respect to your station. Could you tell us what the backlog clearance rate in your station was in the last report?
In the last report, I seem to have lost the figures.
Okay.
I seem to have lost the figures, but I had them. I looked at them and I tried to interrogate the figures with my staff, with my judicial officers.
Okay.
I think I concentrated. I lost the numbers.
Okay.
Thank you.
Thank you, and I wish you well. Thank you, my lady.
Commissioner.
Thank you, Honorable Chair, and welcome again, Mheshimiwa.
Thank you, Commissioner.
Could you tell us the principles that guide the exercise of judicial authority and how you have applied them?
The principles that guide the application of judicial authority are constitutional, that the powers are donated, judicial powers are donated by the people of Kenya. So how do I apply them as a judicial officer is that I am a custodian of the powers derived. So I apply them by having fidelity to the Constitution and the rule of law. So in whatever I do, I will abide by the principles set in the Constitution.
And how do you balance the constitutional imperative for expeditious justice with limited judicial and administrative resources?
How do I balance with expeditious resources? The resources that are bestowed upon the judiciary, there's always a deficit. I would say that we have a deficit in terms of resources. How do I balance these imperatives of the Constitution is that these are public resources, and I am a steward, and I am the custodian of these resources. So I am supposed to apply them as diligently as possible, knowing that I am holding this in trust and as a people servant. Specific examples? Maybe I would say the biggest resource that we have in the judiciary is a resource of time and human resource. So that how do I do that? By respecting, out of respect, our values in Chapter 10, accountability on how I spend my time and how I expend my duties. I must be accountable to the members of public. Other resources like infrastructure, there should be no finance. I would say that there should be no waste. It should be prudent management of resources to ensure that there is no wastage of the resources that have been bestowed upon us by the people of Kenya.
Okay.
Yes.
Thank you. I wish you all the best.
Thank you, Commissioner.
Thank you, Honorable CJ. Mheshimiwa, I have one or two questions for you. Begin by describing your leadership style and tell us how you promote positive interpersonal relations at your station.
My leadership style, Madam Commissioner, I would say that I am a transformative leader. I am a leader who is visionary and a leader who inspires. How do I do this at my station is to make sure that everybody is heard, there's inclusivity, and at the same time, I also have a duty to recognize the diversity within the station so that everybody feels accommodated at the station level.
Okay.
Yes.
We've gone through your CV, very elaborate, looks good. We've also done our background checks on all candidates, and I'm looking at yours. Quite a bit of positive things have been said about you. There is one that I will single out that says, despite her strictness, her way of handling difficult stuff is commendable, and she follows through until the staff makes a turnaround for better. I think this is commendable. Maybe you could tell us what you find challenging, the most challenging thing you find about dealing with the staff that are working directly under your supervision.
Staff dynamics. I would say that what I find most challenging, I would not say that I have a solution to all the problems, but I've been lucky to say that I've been lucky to work in stations where I am able to bring the staff together, and I do so by listening to them. What I might find a little of a challenge, which I'm learning to navigate, is dealing with the Gen Zs, as opposed to the traditional, being a magistrate for 23 years. I think there's a really paradigm shift in the ways that we operated and how the younger generation operates. So you have to really bring them on board. You have to listen to them, and that is something I have learned to maneuver with them, and let them own the process and the station. Eventually, they turn out to be the very, very, I would say, the biggest supporters and movers of any agenda, as long as they buy into your agenda.
Do they ask for flexi working arrangements? And how do you handle that?
Do they ask? The induction that we give them is that we are supposed to work from 8 to 9, yes? But as far as the judiciary is concerned, it is hard to give them the flexible working hours. But at times, some will ask, can I work through lunchtime if I have to leave early? So they sit through lunchtime, because most of the work is being done online. So I've had situations where some have asked whether they can work through lunchtime and leave early. So as long as they demonstrate that, I'm easy with that, and I'm able to accommodate them.
Okay, on need basis?
On need basis only.
Thank you. Thank you, and I wish you well.
Thank you.
Good afternoon.
Good afternoon, Commissioner.
Right. How can technology be used to improve access to justice?
Technology can be used to improve access to justice. I would say practical examples will be the virtual court proceedings, which have made the access to justice very, very easy, in the sense that even people in the diaspora are able to attend court virtually and give evidence. I would also say that expert witnesses who might not make it to court, few expert witnesses from the government chemists, from I would single out government chemists, because where they have to produce reports, they're able to do that virtually. In terms of access to justice, when we use the video link to undertake trials with vulnerable witnesses, or protected witnesses, that has really enhanced access to justice, to name just a few.
How would you ensure that the use and application of artificial intelligence does not compromise access to justice and reputation of the court and the judiciary at large?
A court owns a judgment, and at the end of the day, you are, or as a judicial officer, you own that judgment. At this particular time, we're looking at artificial intelligence as more of a facilitative tool to assist in research. And my take is that in terms of application in judgment writing, we are not yet there. So I prefer to counter-check every other information that is brought to court to make sure that that does not compromise the quality of work. So that if it is submissions and a particular case has been cited, I still have a responsibility as judicial officer to confirm that that is a particular case. So I would say that we have to draw a balance in how we apply artificial intelligence.
Thank you, and have a good afternoon.
Thank you so much, Commissioner.
May I? You've just told us how technology can be used to enhance access to justice, but how can technology also, how can the use of technology impede access to justice? And how can you obviate such challenges, if there are any?
What I think of is it is assumed at times that everybody has access to this technology. So it can impede when care is not taken and a member of public or a litigant is not able to sustain through a full trial. So that would impede someone who does not have the technology. I'm thinking of a case which has very voluminous documents, or where the court needs to observe the demeanor of a witness.
How can we mitigate?
Mitigation would be through pretrial. At the pretrial stage, a court should ask, or ideally should ask, and ask parties whether whether they have access to technology, and whether they would have an open court hearing, or they prefer an open court hearing or virtual. That would be one of the ways to mitigate. In other court stations where their members of public can have a kiosk where there is a laptop and there's the court internet, so they can testify from or can approach the court through the kiosks.
Thank you.
Thank you.
Honorable Commissioners and Honorable Mutuku, that was quite a robust engagement with you.
Thank you, my lady.
This afternoon. I think this brings us to the end of the interview. But before we release a candidate, we always give them an opportunity also to engage us. So the floor is yours.
Thank you, my lady. Mine is to thank the Commission for giving me this opportunity to present myself. I am here to present myself to ask for enhanced jurisdiction and more responsibilities. So mine is to thank you so much, and the good work that you continue to do, and that the support that you give us as judicial officers and staff and the entire judiciary. So we are very, very grateful for that. Maybe, Chief Justice, what I would maybe like to point out, following up on the Honorable Attorney General's issue on the issue of virtual sessions. Just a communication from the sentiments that we got from the open day. That was on the 31st of January. As part of mentorship, there were students who felt that we are not having social contact and say that they are not feeling mentored enough because most of the court sessions will be virtual. And as we were interacting, they would ask, "Oh, this is you. We've not met. We've not met." And that also took me back to thinking of mentorship and the court decorum, because in some cases, some of these young lawyers will never make to the courtroom just to see the decorum. I recall, if the Honorable Attorney General allows me, when I was in the year 2001, when I was doing my pupillage, and I remember when we were in Sharia, the Supreme Court, the Honorable Attorney General said, "You never abandon your client." Because my pupil master wanted to leave, and she said, "You never abandon your client." So that is the kind of interaction I'd feel that these young and upcoming lawyers might be missing out. So maybe food for thought for the judiciary to see how we can enhance mentorship on that. They said they're feeling that they're not having the social contact with us, which in Kerugoya, with the leadership of Justice Edward Murithi, we've started the Inns of Court again, so where we are meeting these people. So thank you so much. That is
Very well.
My take. Thank you, Chief Justice. Also to thank you. In the year 2023, Chief Justice, if you allow me, this is the last one, you allowed me to host the Chief Justice of Ethiopia, Kebede.
Yes.
And on the sidelines, one of the registrars told me, as we were exchanging the stage document and most of the publications that we have, she said that we are very lucky to have you as a Chief Justice, and commended the stage. And she kept on thinking about it. I said I would pass the greetings and congratulate you. So thank you, Chief Justice. I never got an opportunity to do that, and thank you so much. I wish to do that now.
Thank you. Thank you. The commendations and greetings are well received.
Thank you, Chief Justice.
I hope in Kerugoya you can organize yourselves to be having open courts once in a while.
We do.
Yeah, so that those who are feeling disconnected can have an opportunity to appear in the open courts. I think every court is planning, because these are hybrid. They are hybrid. There are people who come physically, others came online. So you can have, like, say, a week when you do an open court, and, people can interact. So thank you very much.
Thank you.
Point well taken. I hope we'll receive that report from your open day, because we are collating all of them, and we are preparing a matrix of the action points to take out of the feedback from the members of public. So thank you very much. And on behalf of the Commission,
thank you.
We want to wish you success.
Thank you.
And encourage you to continue doing the right thing.
Thank you, Chief
Once
Justice.
we complete the exercise, which is highly competitive, we will get in touch with you. So you are now released. You can carry the lighting pan and your water.
Thank you so much, my lady Chief Justice.
Yes.